I'd like to call to order the informational meeting of January the 6th. I'm going to ask Commissioner McClure if he'll do the invocation and Pledge of Allegiance.
Most gracious Heavenly Father, come to you this morning for we have the business that we have to do for the county. We ask for your wisdom. You are indeed an awesome God. You tell us in your word that your thoughts are higher than ours and your actions are higher than ours. Nothing happens unless you cause it or allow it. And Lord, we just thank you that we can rely upon your sovereignty. We can rely upon the fact that you have promised to walk with us through anything that we incur. And as we look at the business this morning, we beseech the wisdom that you promised. Help us to be able to discern the correct path and the path that would be according to your will and the best for this county. In Jesus' name we pray. Amen.
Amen.
I pledge allegiance
to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
I'm always afraid I'm going to forget about half of that.
Commissioner McClure, if you want any veterans.
I know there's no veterans out there, are there? All right. Well, we want to honor the veterans every time if we can, so.
I'm going to turn this over to Casey for a brief minute.
Mr. Chairman, I'm not even sure how much words I have. Even just talking about it makes my throat start choking up. I think everybody knows this past week, Commissioner Shores had a tragedy beyond comprehension occurred in his family this week. So I just want to say my heart, personally, and prayers go out to the family, the Shore family. And I know I speak for you all as well, and I'll open the floor up. I think there's been, plenty of flowers and things sent, people trying not to bombard you, but we are here if you need us. So I just wanted to make that statement. Thank you.
I appreciate that.
Absolutely.
That's something that no parent should ever have to go through, but it's part of life sometime.
Mr. Chairman, if I may, I would just like to say that I'm going to attempt to get through this, but and I'll be brief. The people in Davidson County, I just don't, my family don't have words. The text messages, the phone calls, the emails, the Facebook messages, I mean, it'll take me a year to answer them all. And the love that this county has shown my family, words can't express how much we appreciate this county, this board, the staff here at the county. I know that everybody has been praying because that's what's helped get our family through. So I just really words can't convey to the people of this county and the staff here at the county how much we appreciate you and how much we love each and every one of you. So thank you all for everything that you've done for us. You're right, Mr. Chairman, no parent should have to bury their child. But like Commissioner McClure said a few minutes ago in his prayer, nothing happens that God doesn't cause or allow to happen. So even though I don't understand it, and I probably never will, there was a reason that he took my daughter or allowed her to be taken. And I may never know that, but I hope that whatever that reason is, that maybe someday we'll know. So thank you, Mr. Chairman, and thank you, everybody. I appreciate it.
Well, James, thank you. And, my belief is that God has told us that in time all things shall be revealed. So we'll have an answer one day. Okay. We got anybody who hadn't registered can register for a public address. If you're interested in speaking at the I'd like to have a motion to excuse Commissioner Wofford and Elliott.
Commissioner Elliott just texted me he's not going to be able to make it this morning, so I thank you. I just wanted to.
We got a motion.
Second.
Second, Commissioner Shores. All in favor?
Commissioner Yates.
I'm sorry.
What?
Commissioner Troy.
Troy, okay.
Mhm. And Commissioner Shores. All in favor? Opposed? Okay. Are there any changes to the agenda? May I have a motion second to adopt the agenda?
So moved.
Please cast your vote. Oh, do we need a second on that?
Sure.
I think Mr. McClure beat me, so I'll second it.
Okay.
Okay.
That's print 11.
Commissioner McClure,
Thank
could I have your vote, please?
You got mine, Debbie?
No, I don't. There we go, I've got it, okay. Commissioner Troy, could I get your vote, please?
Okay.
Cold weather, this thing's pretty slow this morning, isn't it?
Okay.
Might be me, the weather's affecting.
All of the votes are in. And that motion carries by a vote of 5-0.
Jason, we have anybody set?
No, sir, Mr. Chairman.
Okay. Turn this over to Casey,
Mr. Chairman, I've got some handouts here. I'll just start
from
with
Sand Hill Center
Appreciate you
first.
pass them down. Was a way to gather my thoughts on this topic, so if you'll just indulge me just for a few moments to go through kind of the slides here. We're at the final place of all of our transition point here with Sand Hills. If you remember back in November, the board discussed, ways to get involved in utilizing these reinvestment funds to a more of a county-wide perspective. Sand Hills doesn't do direct to nonprofits. We don't either. Both of us, we weren't going to ask them to violate a policy they have as well. So we were thinking of strategies to affect the most folks with limited amount of funds. They only have a certain amount of these Medicaid dollars that they call reinvestment funds that can go towards such activities. So if you'll just follow along with me on these slides real quick, I want to go through what we've come up with as a plan, start addressing some of the mental, behavioral, and substance abuse issues with the best bang for the buck with the limited amount of dollars we've got potentially available. So again, like I said, in November, we completed the transition from Cardinal to Sand Hills. If you remember at that time, the board asked staff to take a look at, using these reinvestment dollars in some key areas. Is kind of what I've put here. DSS with our Child and Adult Protective Services to do assessments, more or less, assess folks' mental and behavioral health and then find them help, basically. We've got jail inmate and school mental health and clinical assessment treatments and substance abuse issues. So the three areas we kind of were focusing on with, again, trying to backstop into how much money is available that we can do this with are these three areas: the jail, DSS, our children in DSS, and then potentially anything we could help with the same issues with children in schools, and ideally pair those children up with if they're our own DSS kids, get some linkage. So the board has also agreed to kind of evaluate the need for these resources related to these areas, try to get some more recruitment and training for foster care as well, and I'll get into that in just a minute in another slide. So let's start with the first one here, clinical assessments for CPS, Child Protective Services, and Adult Protective Services. We kind of looking at options here of two options, and it's really based on cost, and I'll give you an inkling in a few minutes as to my conversations with Sand Hills. Option one would be having a full-on clinical therapist and a case manager. That clinical therapist, a little higher-end position that does these assessments with our own in-house, our DSS kids. And so there you got a net cost as well, because there'll be some reimbursement that can be claimed in DSS for this. So you kind of get a net cost, what you spend, and then what's going to be drawdown revenue. If Sand Hills would have had a problem with spending that much money, the second cheaper option is just to have the case manager, obviously. On every one of these slides, you're going to notice at the bottom this goal, and this is very important to me because we've had these conversations as a group about, we've got a limited amount of funds here. We want to have the biggest impact on basically society out here in the county. what's the goal? What are we trying to get at the end? I'm trying to keep this simple as well. So if we do, RFPs and RSQs to bring in contractors to do such work, which is where I'm getting to at the end of this, each one of these have a goal to get, and for this one, it's expedite these clinical assessments and treatments and get to faster placements. And Commissioner Yates probably knows exactly, he's sat through enough of the DSS meetings, he knows exactly what I'm referring to. Getting timely, fast, quick, effective placements. Slide 2, on the jail, similar concept. We reviewed with what Sandhill sent us as programs that got going on in these different counties, Rockingham, Rohan, Cabarrus, Moore, and I've actually talked to a lady that does the work in Moore County. Same basic idea, having a clinical assessor that does the mental health needs, usually post-discharge. So again, up at the jail, and we talked about, we really didn't want to, if we could help it, having someone try to do both the DSS job and the jail job, if we could help it. That's the trick, just again, a certain amount of money can only be spent. The goal here, again, reduce recidivism rates. In other words, we don't want to see you back, and we want to have some kind of positive societal impact. If I have my druthers about this when I do the RFP, I want to focus on how are you going to show me that Casey was incarcerated, got out, and is now a productive citizen? Did he buy a home or get a job or, not coming back to the jail, basically. Simple as that. Go to number 3 here with the schools.
Can I ask a question?
Yes, sir.
I'd like to see something on a pre-jail. We put these people in jail, a lot of them, and they don't really belong in jail. They have minor offenses. They cut their medication, and then they act out in there, and then they go to solitary confinement. And then when they get out, they go right back in the same stuff. Now, I like the post-discharge, but I'd like to have an assessment on the front end, if it's possible, to determine which of those really need to be in the jail and which can be diverted into substance abuse or whatever.
At the end, let me tie all that together at the end of this. I'm almost there because this is not very long. Same premise with the school-based assessors. We looked at some counties. Again, these programs came from Sandhills to us to kind of evaluate, here's what other counties are doing and such with these funds. So we evaluated these counties here. Again, option being basically similar to DSS, a therapist, high-end clinical type position, case manager, housed in DSS so that person can try to get that linkage between, we've got DSS kids in the school systems. I've talked to the 3 superintendents. They're more than on board in terms of whatever we need, space, accommodations, etc. And with this one, I want to see, again, what we want to see: grades, attendance, the child being back into being, again, a productive member of the school system, basically, which is a productive member of society as well. I mean, those are the things I want to see in terms of if we do an RFQ or an RFP. That one's there. So go back to the flip slides to number 6. We got this whole concept of, okay, we do all this assessment, we drum up all this business, so to speak, but what about where do they go? I think Commissioner Shales brought this up several times, and now that I've kind of thought through it and see it and interacted with some of these folks that do it for a living, I see the quote-unquote supply and demand side of this equation. So we want to talk to Sandhills, and these are some of the things they're already doing. This may not even be with reinvestment dollars. These may be with things that they already have funding for, to provide training for foster care families, to keep kind of low to moderate children with mental disabilities in the home as best we can. But to do that, those foster care families have got to be trained and prepared to handle that. To provide maybe private foster care placements if necessary. They're expensive, potentially, or out of state or something like that, for high-end placements if necessary. And to provide foster care better payment rates to those families. In other words, an enticement to do some of the training and deal with some of the harder, arduous issues that come with being a foster care parent. So, again, that may not even be with reinvestment funds. Some of these things right here is things that Sandhills are already do with other funds. I just wanted to put that on the screen and point that out, that if we do all this assessment, there needs to be another side of the equation. And that's trying to expand the availability, basically, locally and regionally. I didn't put a cost on that again because that's something that they already do. If you flip over, so what will we be asking?
What
Sandhills?
page are we flipping
7.
over?
Page 7. Yes, sir.
Okay.
So what are we asking this morning with all this is we got an estimated cost here of Sandhills between around $300,000. And again, that's about their target point for what they have in terms of extra Medicaid funds available to pump into the community. For each jurisdiction, you gotta remember, they've got 10 or 11 counties as well with them. And we're looking at here, with adding up all these, I call them FTEs. They're not FTEs on our books. We're talking contractors or physicians, but we're looking at 4 to 5. If you do one in the jail, a couple at DSS, and then you've got a couple for the schools, that's how you get that number. So what we're asking this morning is staff seeking direction on moving forward with RFPs, RFQs to bring back to the board to, again, talk about what Commissioner McClure had, maybe the front-end assessments of the jail and, again, the discharge. But I need to do proposals to find these assessors. That's the next step. And then we'll work with Sandhills after approval from you guys that, yes, this is what we want to do. We'll give it to them, kind of get their approval because they're obviously paying for it. And then we'll just move forward with implementation.
Casey, do we still have day reporting here? No.
I don't think so.
We don't?
No. Think so.
Because that was post entry to the jail and exit the jail also,
Right. Not that I'm aware of, no.
They quit funding it
Yeah.
altogether, so most of the day reporting centers throughout the state are no more.
You may have mentioned this, and I know you have. What's the total dollars amount Sandhills willing to?
It's about the 300. Let me put it this way. They don't know every year how much extra Medicaid funds are going to be available to do this reinvestment program. They have somewhat of an idea. So 250 to 3, that's why I've kind of landed in that range. And then, and the thing is, and I've talked to Victoria about this, she recognizes we're the new kid on the block coming on, and I got to give her credit, a shout out. I mean, she recognizes we've probably been underserved. These are her words, not mine. And so these are things that she sees. I think if it was a little above that, they would help work with us on these. I've talked to her about this plan. She's on board. So that was positive to me. I was a little nervous even this may be more asking for what they could do. But I think these are probably doable things. Our next step, though, is to have Dwayne do an RFP for these services, or an RFQ, and bring it back to this board for approval. So that's really what I'm asking this morning, is there an appetite to move forward?
Well, from what I'm reading here, I can tell you guys, the one I like to begin with, the number one, is the enhance in school performance.
Yes.
Because if you can catch them young, again, like you said, I think before, maybe you catch them before they get into jail. I mean, so if you're going to start somewhere, start at the root.
Well, and two, the reality is you got X amount of dollars to deal with. You got to decide where you're going to put that priority at. Because if you continue, my opinion is, if you continue down the same road as what I refer to as the Optimus theory of governance, you got tendrils going in so many different directions. You got a little money thrown here, a little money thrown here with very little effect. And so we just have to see what it is maybe that society across the nation, we're not just referring to Davidson County, has been doing wrong. And I think if you want to reduce those people going into jail, we have to start looking at trying to address these children when they're young.
Right.
I think that's
130K, so there's another 200,000 left to.
But I want to ask Casey, what we're looking at here, is that in addition of what is already, for example, the sheriff has an online assessor now, I think?
Yeah, this is.
Is that where that would
stay.
That'll stay. So this is
right.
an addition of.
Right. And that online psychiatrist does a lot of the intake part, but Commissioner McClure is addressing a little bit different issue, and I understand what you're saying. But I like this plan because it's targeted to these 3 areas, because you're right, we don't have, billions and billions of dollars of funds to attack these societal issues. It's targeted, and it's also fluid. We as a board, we can do the proposals, move forward with implementation. Part of this proposal is I want to really lean on these folks for reports, whether it's semi-annually or quarterly, et cetera. I want them, to us and to Sandhills about these goals. That's why I'm making the goals simple. I want to know how we're going to know if these goals are being met. And maybe other goals too, but at least these. And then have that report come back to you all. So we're going to keep, and if it's not working, we've got the ability to move. With these funds, we can move around and change the programs or talk with Sandhills and do something different. So, because this is affecting human beings, and as you know, dealing in human services, we're gonna have recidivisms, we're gonna have disappointments, we're not gonna be able to help everybody. So that's okay. We'll get through with what we can, but if we see that the programs aren't working, we're not locked to this. We can move, and that's what I like about it. And I like Sandhill's approach in terms of the mentality of allowing us that freedom.
Mr. Chairman, one thing I'd like to know, and Casey's dealt with them a lot, and I understand there's a honeymoon phase in everything. So that we're new to them, they're new to us, and right now it's yes, 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 we'll do. Is your impression and your feeling like that will continue down the road?
Sir, yes, sir.
Okay.
Yeah, because these funds are usually available every year, but it could be a year where they're more limited. You know, so we'll just have to talk about that on a year-to-year basis. It may be a year where 300 is not the option; it's only 150 or something of that nature. But I think there's always Medicaid funds that they have, and by law, with those Medicaid funds, they've got to put them back in the community. And that's one of the problems Cardinal ran into. They weren't doing that, and that's one of the reasons why they started a process, you know, to kind of go out and do gather the nonprofits together and talk with them about, hey, you know, what can we do to help you? They weren't doing that all along, and then kind of just started at the end of the fray. That's not how this one works, and that's not how Sandhills does it. So that's why they usually come to the counties and say, what priorities do you have?
I agree with Commissioner
These are the
Yates.
best three I can think of that really gets at, of course, if we had endless amounts of funds, like Mr. Shell mentioned, we could go after lots of different things. But these three, not facilities, but areas, there's no doubt in my mind, this is the largest concentration of mental health issues in the county.
What kind of response did you get from the superintendents?
They were extremely excited. Never had this conversation before.
Yeah.
And as you know, over the years of kind of working with the LMEs, you know, we've never had this conversation before. This is new to us. Having the ability and freedom to even talk about this and do it is new to us, and I'm more than pleased.
And we have to get them used to using this. I mean, if we
Right.
do it, we gotta get them used to using it. And there's no need to have a service and they're not using it to the fullest extent, you know?
Great.
The young people that we deal with in law enforcement is atrocious anymore.
That's where the trouble starts, isn't it?
I mean, you know, it seems like it's come a complete circle. You know, now we deal with so many more youngsters, the gangs and everything. It starts right there in the school, and it just builds from the school. So I 100% agree that we've got to start and start helping them while they're young, and I definitely think that should be, I guess, maybe number one is the school stuff. So I mean, yes, we put people in jail that I don't think should be there, but like it's been said already by this board, if we can catch them when they're young and we maybe can change their focus and change their thought process, then, you know.
Well, one of the things you mentioned was the differences in behavior of young people today in comparison to the past. But, you know, the truth is we have so many kids born already an addict.
Oh, yes.
But we're not doing anything about that.
Absolutely.
And no wonder we're having some problems with some young people as they grow older. They're born with addiction, and addiction can bring on mental illness. You know, if left untreated, then if we can catch them earlier and minimize the effects of that mental illness by having them properly diagnosed and treated, then the long-term effects of mental illness doesn't mature. We don't allow it to mature because we've caught it early enough that we can do what needs to be done. But I still say that different subject, but we need to take some action as a society on these babies being born as addicts.
I agree.
And they say we can't do it. We can do it. We can do whatever's necessary to protect society. But
I agree.
I mean, they're doing it with this virus.
You know,
And this is a pandemic in itself.
one thing James said about the schools and the kids, you know, we got a whole lot of one parent families now.
Yeah.
And when a mother can't make ends meet and she's got one son that can bring in $200 or $300 a night to her, she's not gonna ask him where he got it. She's gonna take that money.
Yeah, we've seen that,
Yep.
we've seen that.
The problems that we had with Cardinal that is addressed in what you have here is the placement. And I think that is very important, that whenever the DSS gets these folks in there, they need to be able to place them someplace.
Amen to that.
We've already had some, Trish has had some good experience with them here early with some had some tough ones here to start right off the bat in December. But part of this is getting that assessment done too, quick as possible.
The other thing is we've got, a lot of money coming in from the substance abuse folks. So we can address some of the substance abuse issues with that money and spend the money here, like they're talking about, more on, preventive in mental health and dealing with what the DSS has. But if you look at the statistics, the suicide rate among veterans and the homeless rate among veterans is tremendously high. And it's going to continue to be high because there's a whole lot of veterans that's getting out. And they getting out with this PTSD and they act out and then they wind up in jail, which is ridiculous. But that's another story, I guess, another time to deal with it. But we need to do something for the veterans as well and target veterans to make sure that, the veterans, that when they sign that piece of paper, they go overseas. They don't know whether they're coming back or not. So their contract is their life. And then they perform over there, they do the service, and they come back home and nothing.
That's true.
That's true. I got a question, Mr. Chairman, if you don't mind. Trish, you got a second, please? This DSS CPS option, tell us exactly how that's going to impact you.
So we were fortunate enough to have, through Cardinal, that was one of the positive things we had with Cardinal, was they placed a person here in our building. And that person we were able to staff our cases with. And they were able to assist us with expediting the assessments, clinical assessments for our kids. And that allowed our kids to be placed a lot faster.
How long did Cardinal have that in place here?
They started in February, so we had it until they exited.
So just a few months, whatever.
7 or 8 months,
Right.
yeah. And it's because we were so vocal. They did not do that for every county. And so we did have a lot more success in getting kids placed, leveled, so we knew if they needed to be in a leveled placement or were they regular foster care. So that was allowed us to expedite where they needed to go.
So can you give me an example of what difference in days the placement, once we had someone here?
If you have somebody on site, then you can bring the child in. So one of the goals of what we're hoping to do with Sandhills is that in CPS, when we get a case and we see a family in need, we can link them immediately with mental health and hopefully keep them out of foster care from the get-go. What we were doing with Cardinal was when the kids were already in foster care, we had filed a petition, now we identify mental health needs, and we link the care coordinator with our child, and they get assessed. And so now they're already in foster care, and now they go to a facility. What we're trying to do is, if we can get the family wraparound services while we're doing an investigation, maybe it is the family not having the parenting skills they need or understanding all the needs of the child, right? Sometimes we see families who are like, I'm done with this child, take them. We don't want that to happen. And it's because families are overwhelmed. They don't have the skills they need. There are so many kids, you can't even imagine some of the needs that the kids have, and even the most well-equipped parent can't handle those needs because the mental health needs are so severe. And so if we link them at investigation, or when they move to in-home, they need services, the family can get that support and maybe keep them out of foster care, or we can help the family place the child. They are still the caregiver and custodian of the child. We're not the legal guardian, so hopefully it would keep the child out of our custody completely. But if not, we would have an assessment early on and know immediately. So instead of having a child linger at an adult behavioral health setting, which we had happen more
So
than...
this could go on
than
for
once.
months or weeks?
Well, so intensive in-home could be, yes, it could be a long-term solution for a family. Because mental health is not something you can treat overnight. So it depends on the needs of the child. Sometimes it's quick, the parents just need some skills. You have an autistic child, you don't know how to respond. They get tools to help deal with the child, and we could get out of their hair, so to speak. Or it could be something that the child is long-term. Parents have mental health issues as well, so we would be linking the family with that. So yes, it would streamline it, but if it is a child who comes into care, if we have somebody here on site immediately, you're already starting that process. You're not waiting until the next available care coordinator. You're not having to send an email and then wait for them to assign somebody. You have somebody on staff.
And that could, the old way could take a day or two or three before you...
Or a week.
longer than that.
I mean, it could take longer depending on, if you have weekends, holidays, time of day, whatever's going on. Sometimes it took longer. Our goal would be that it would be pretty quick. And Sandhills, I will say, I heard Casey say they've been very responsive, and we've had some, unfortunately, very difficult situations already early on. Kids disrupting, kids in the ED waiting, they've disrupted and they're waiting they need a higher level placement. They've been very responsive. So
Trish, when you're saying, to Commissioner Yates's question, when you're saying immediate with that person here, like immediately, like right now, this second, or is it still an hour or 2 days?
So obviously, right now we have 150, maybe 60 children in care. So if one disrupts and you have one person, 2 people, it depends on what's going on at the moment, right? We filed 6 petitions this week. So sometimes it doesn't matter how many people you have, you're not going to be able to do the...
But without that person, you wouldn't have been able to file those petitions this week?
Well, petitions are going to get filed regardless,
Okay.
but the care coordination would happen immediately, so okay, this child's coming into custody and they have these mental health needs, and we need to go ahead and try to get them leveled. Or no, these children are not, they have, they're, I don't want to say normal kids, but they don't have the severity of mental health, and they can go down a regular path, and we can find a regular foster home for them. And it makes the foster homes that you're sending children to feel more comfortable because they know the children don't have fierce behaviors and things like that. So
I think what I'm hearing her say, and for me sitting on the board, I think what I'm hearing her say is probably they're going to get assessed that day.
I would hope, yes. Obviously
her
you have
own-
a huge volume of something going on.
Versus weeks?
So it's not
or
gonna be 10 days for
Not
the...
going to be 10 days.
Right.
Let me say this as well, because a lot of our cases don't come in and we're immediately taking a child. So we would have time that in investigation, the social worker's already staffing with the assessor to say, hey, this is what's going on. And they can already help guide us through getting the resources for that family. So that's the piece that I'm hoping we will really be able to build on and keep the children out of foster care. The need once a child's in foster care is huge, but getting the front end, getting the prevention is really what we're hoping to do with this, right? It's about identifying the needs early on, and can we keep these children out of our custody?
From the first visit with the family and the child.
Exactly.
They start working
As soon as the
together.
social worker goes out, they can start staffing with the care coordinator or clinician, whichever model y'all decide on, but that we start staffing, that we say, this is what we're seeing, and, help us. And that was one thing that we were very fortunate to have. We had an excellent person with Cardinal. And so it's actually finding the right person, because not every county had a good success with their care coordinator that was stationed in the county.
Trish, let me ask you a question. When you talk about the assessment, and then I guess it's based upon the severity as to placement, does that require court action, a signed petition? And if so, how does that delay the process? And how on board is the court system in addressing these immediately?
Okay, so for us to have a care coordinator for a child does not require court action. Is that where you're at?
No, if they direct them somewhere or taking that child into your custody, I'm not sure exactly how the process is.
So for us to take a child into our custody, yes, we need to, the court has to approve that. So we take the child into our custody, and then we go to court to say we would like to continue to have that child in our custody.
What's usually the time span of that happening?
So we have a 7-day hearing. Attorneys? So this is legal. I don't want to start misspeaking. Thank you, Sherry.
Good morning. When we file a petition, we have to take it into court within 7 days.
Take your mask off, please.
Within 7 days.
Within 7 days. Typically, if a child has been evaluated and the clinician recommends a placement for that child, if the parents agree to that placement, then usually no court action is required. The parents give consent and we don't file a petition. If we're unable to locate the parent, or for some reason that parent refuses to comply with that treatment or abide by that treatment, and we are concerned about that child's health and safety, then we would petition the court for custody of that child and place the child in that treatment facility.
Is it necessitated the 7 days for notice period?
Sherry, would you back up a little bit?
Sure.
Talk about 12 hours placement and then talk about an emergency order to assume custody. Because I think what the chairman is trying to hear here is the urgency by which DSS can intervene.
Certainly. Occasionally we have situations where we don't have time to go to court and we don't have a whole lot of time to meet and decide we need to take custody of this child. We may find a child there was a traffic accident, a parent's not able to be present and make decisions for the child. DSS can assume 12-hour custody, meaning that child comes to DSS usually. Typically, I'll get a phone call, could be in the middle of the night or could be whenever, and then we sit down and decide, yes, we have enough legal action, we need to file a petition and keep this child in our custody.
Emergency order?
Emergency custody,
Okay.
yes. Typically, that doesn't happen with cases where a child needs mental health intervention immediately. Not usually. We usually know about those in advance. That's not a typical situation where we would have to have a clinician, someone evaluate that child immediately and then proceed with filing a petition and getting that child into our custody.
Okay.
So just...
If you only have, I'm trying to understand this, a 12-hour option there. What happens after 12 hours if the court action isn't taken care of?
Then that child goes back to the family, goes back to the parents. Yes. That we typically try not to use that except for very, very limited circumstances.
Yeah.
And that would be a situation, we get into the situation then where DSS takes custody of a child without the court intervention and without, there's just not enough time to process what's going on with the family. DSS doesn't like to do that, and I don't advise to do that very often.
Yeah.
Because you're getting yourself in a situation where there could be some liability.
We had a situation recently where a child's parent was unavailable on the run. The mom was incapacitated. We had to take 12 hours. But we sought court action. They gave us approval. We brought the child into custody.
So you were, it was handled within the 12 hours?
Right.
Yes.
But we had no
Yeah.
parents. So
Yeah.
that's usually
Right.
the situation where the parents are, you may hear stories on the news, a child found wandering, down the street.
Yeah.
You don't know where the
Yeah.
parents are. Those are the kinds of situations that you would, or there's a critical injury to a parent or something like that, where
I guess
they're not able to make decisions.
I guess my question was, is the court on board with this as far as expediting it when it needs to be expedited?
Yes,
Yes.
usually,
Okay,
yes.
approachable,
So
yeah.
we've got a very, positive court relationship.
Good.
And typically, when we take a case to court, it's because there's been a lot of thought-out action, and I think the social workers will tell you when they come to me and they want to file a petition, we go through all the scenarios and all the reasons why we shouldn't file and why this is the only option that's left for this child. We don't take a child into custody just because we have the ability to do so.
Right.
And the courts know that as well. We don't file petitions willy-nilly. We do it because there's a child that's in serious need.
One of the other things that we had issues with Cardinal with was the level situation. Is that gonna be better with Sand Hills? Do you have a
So
better?
I'm gonna tell you, we've already had several experiences where, Cardinal would not level a child to what we thought was an appropriate level.
That's
Let's
what
say
I was
a
talking about.
PRTF, which is the highest level, unless they'd gone through all the levels. We've got 2 kids right now who are in what we call level 2 therapeutic, who are immediately going to, PRTF, which is the higher level because of their need. They disrupted, they're in the ED. Sand Hills is working actively to try to place them into a locked psychiatric facility, because that's what they need. So so far we've been very happy. Now, the issue we're finding is there's not enough beds, right? Not enough treatment beds, and so that's not something Sand Hills can create, but they are working with us more actively, and the kids get more than one care coordinator if they have dual diagnosis, and so they've got a lot of experts working for them at Sand Hills.
One of the things they had was, y'all felt they ought to be at one level, and the physician that was on board with the LME said it shouldn't be that level, it should be something else. You still experiencing that?
We have not had that. I'm not gonna say it's not gonna happen, because there will always be a case that, will cause, but we have not had that happen yet. So far so good, I will say.
That's good news, because that was a real issue. You start hassling over what level, and the kid's sitting there without the proper care.
We had a early situation where I advocated for PRTF. I'm not a clinician, but I just felt based on what the child was going through, and Sand Hills immediately jumped on that, and they re-evaluated the CCA, the clinical assessment, and the child got leveled and the child unfortunately had to go to South Carolina for placement, but that child got placed within a matter of, unfortunately, it was a few weeks, but as quickly as they could find a placement, and they leveled him up very quickly. So that's been a positive for us.
Do you think you've seen this proposal that Casey has?
Yes, we've talked a lot about that.
Are you okay with that?
We feel very good about it. Yes, we think there's a lot that we can do with that.
I think we ought to move forward on it.
I do too. I want to thank y'all for what you do, okay?
Yeah, thank y'all very much. We appreciate it.
Thank you for being patient with us.
Thank you.
Appreciate you answering the questions, so.
Just a word for Casey on something else that has to do with Sand Hills. Have they got the providers straightened out, where they got the same providers that Cardinal has, so the people don't know how
All that should have occurred during the transition, yeah.
Huh?
All that should have occurred during the transition, yeah.
Should have.
Yeah, as far as I know, I hadn't heard otherwise.
Well, that was what was worried about, people having to switch their kid from one provider to another, and that's not happening.
I have not heard otherwise.
Okay.
I'm sorry to interrupt y'all. So we, Sand Hills made sure that anybody that was linked with a provider, they contracted. There were a couple of providers who were not in good standing with Cardinal. And so though there are a few folks who had to find another provider, or they're doing what they call a individual agreement or a client-specific agreement for that service. What we've said to staff is that if the provider was not in good standing with Cardinal, why would we want to continue to use that provider to evaluate that? But there have been a few situations like that, but mostly all the agreements have been honored, and I think they've worked out. I've only dealt with 2 or 3 situations where a contract slipped through, but Sand Hills immediately went back through. So I think they're on a good track.
Yeah. One of the consumers' concerns that we have with Cardinals is they change case managers all the time, so the people couldn't feel comfortable. They got comfortable with one case manager, and then they switch them off to somebody else. Are we able to keep the people with a particular case manager?
So I have not heard specifics. I do know because, Sandhills had to hire 41 new staff. I think, obviously there was some transition, but I think once they stabilize, it should be good. It seems like Sandhills has really long-term employees, and, I think Cardinal, knowing that Cardinal was dissolving, was creating some of that movement in addition to just their standard business operations. So I think, we'll monitor that, to make sure, but I have not heard any issues. But I do know they've staffed up, so that should be resolved.
Thank you. So what do we need to do? Just give you authority to move ahead with this?
I'm looking for common consent on this one, that we'll do the RFPs and RFQs and get with Dwayne and bring them, we gotta bring them back to the board anyway for approval, so.
I think
That's what I'm
as far
seeking
as
this
I'm
morning, is
concerned,
direction to
we
move
can go
forward.
ahead with what you presented. I think that, Steve and Todd both indicated that, the youth was a major thing, and placement is right up there with it, so I would think that we could go ahead with this. Anybody think different?
I'd say option one on this one.
Oh, and I agree, I left 2 on there, I failed to mention, Sandhills was for option 1 of DSS 2. I left that on there just because I'd already had it in case cost became an issue. And it didn't, so that was very well received.
Okay.
Mr. Chairman, if I might. Mr. Chairman.
Yes.
Forgive me. When I asked Ms. Woodyard to step forward a few moments ago, I failed to introduce her to the board, and I know several members of the board have worked with her, both as our DSS attorney and in her prior employment in the DA's office. But I wanted to make sure that everyone knew Sherry was a colleague of mine and a member of our office, and has primary responsibility within our office for handling DSS matters, and is also segueing over to handling health department matters. And I just wanted to introduce her to the members of the board who might not otherwise know her. Another one of our colleagues, Andrew Howe, is going to speak to the board here in a few moments. And so in the event that I should fail to introduce Andrew at that time, I apologize for
Thank you,
interrupting.
Chuck, and I commend Ms. Woodard, because I don't think we asked a question she didn't have an answer for right there, and I like that.
She's very good.
Yes. Thank you, Ms. Woodard.
Always has been.
Okay,
Donate.
Casey?
Mr. Chairman, go back to the item 9A just for one quick second. So Chuck stole a little bit of my thunder. I wanted to thank Sherry, and in particular, I mean, all the legal staff, but Sherry in particular, and Trish. This completes the transition of LME, which has actually been going on now for a year. And I don't know that we would be here. We would even be here if it wasn't for these 2 individuals. So, Trish, your DSS director, not even, I don't want to embarrass you, Trish, but a couple of weeks ago, spent a night in a facility with a child, her and her staff. I don't have the names of all those staff, but I want to thank publicly that those DSS staff, but your DSS director does it well. So I more than commend them. You know, it goes beyond words to do things like that, but I personally would have never, learned as much about LMEs as I ever learned in my life without them, and I would have never been able to pull it, we would have never been able to complete this process without those 2, so.
When we think about these DSS officers, we had a problem a couple of months ago with people loitering out here at their cars at night. Do we still have that problem?
Well, I don't know about we have not seen anything like that because we've increased the lighting. If you notice, as you've left, in the evenings here, this side of the lighting is much better. That side's going to be done soon. The city comes by and will replace the poles, I guess. So we'll have the parking lot much more lit up here soon completely. And, the goal obviously is to shine light on any kind of, bad behavior, but I have not heard of any bad things going on.
If you hadn't heard anything, they would tell you, I'm
But
sure.
if you remember, the parking lot was pretty dim before, but now it's lit up pretty good, so.
Okay. Casey, if you want to talk about the, Jackal River report?
Yes, sir. Got another, brief handout here, Commissioner Yates.
That's right. Hold
Recently, this is a bit of good news here. I got notified by, Pat Ivy at NCDOT about, donation of a property at Yak and River Park. If you'll flip back to the second page on the map, I can just kind of show you where the property lies. And you see there in the middle of the I-85, it's the blue highlighted area, boundary area there, right in the middle. It's right near the rest home. The tax value has it at $29,490 at about just over an acre and a half, 1.65. All that is required at this moment, all I'm seeking approval to do is send this letter that's on top of this map, stating our intention to accept the property. I think after that, Pat will probably get back in touch with us and maybe need to be some surveying done. I talked to Mr. Marshburn about this recently, and there may even be other property beyond this that's adjacent to this one that is going to be part of this donation package. But for right now, in Pat's email, this was all that was listed. He listed the PIN number here that's referenced in the email, and of course we added the acreage and the tax value. And we've let him know at the bottom part of the letter there what our intentions to use the properties for. As long as it stays in public use, the donation, as far as I understand, is okay to complete. So what I'm requesting for the board this morning is permission to move on with sending this request to essentially accept this donation process, or kick off this donation process and complete it.
I think we ought to do it. You said put it on the January 10th consent agenda. I'm okay with that.
Well, can we do this one with common consent too? With common consent, I think I can move forward. Chuck, you remember that? I mean, I can send this off now rather than wait. If y'all are okay with it, I'm okay with sending.
That's what
this
your note had. So.
Yeah.
But point that property out to me again.
It's right there. The teal blue, right in the middle of the page almost. It looks like almost like a rectangle.
Little blue outline there.
And I think that piece of
All right,
property, once we get it, actually connects us to the Trading Ford Memorial.
It's a little short.
I think
It's
so.
on the road
It's
going
just
down
so
the
short.
Wilcox Bridge, right there on the right before you get to the road that turns off.
Right here, I think. Right here is
Yes.
The monument.
Your truck, you got
Yes, right.
Thomas's.
Okay.
You come off.
And we
the
own
ramp
these two pieces of property here.
Down here where we built that new little overlook or whatever.
Yeah, okay.
That's a bridge.
We'll have the water
We own
rights.
those two lots across the road there.
We'll have the water rights for us over with.
Go ahead, move forward.
Okay, Casey, you ready?
Chairman, I'm okay. If that's common consent, everybody move forward. I'll get that off the pad. Chuck may have to review everything. And again, we may have to do a survey when it comes in. I'll let Pat guide us from here. He just simply wanted a statement from the county saying we're okay.
The board may recall the DOT has previously conveyed properties to us, where the dog park and the gravelled lot is out there. That was part of a 9-acre tract that DOT previously conveyed to us in the same style.
Okey-doke. You got the whole meeting here, don't you, Casey?
Yes, sir. Yes, sir. This one coming up next is unfortunate, but it is what it is. Mr. Chairman, I'm ready if y'all okay.
Mm-hmm.
We're ready for 9C. I got handles on every one of these, so I'm sorry to bombard you so much paper I'll use all year long, but some of this I felt like we had to have some context and ways to navigate the topics. I'm gonna ask Andrew and Tony and Casey Tarleton to come up, because I may need their help with all this, if I can borrow you three gentlemen. I'm gonna do my best, but y'all are good at filling in the gaps. I think the board's well aware of this, what we call the Biden testing vaccine mandate, or ETS, OSHA ETS, if you will. I think, the board's been kind of kept abreast of what's been going on. This started, I think, about October. It may have even been late September, if you'll recall, where the White House put out an executive order stating that employers with 100 or more employees will have to pick an option, either mandate or get everybody vaccinated or do testing of the unvaccinated. That's kind of how it started. I saw it really early. And then kind of try to keep an eye on it to watch what the developments, because they put timelines on it. I knew the lawsuits would come really quick, and they did. And so, if you'll remember right around, I don't have exact dates in my mind, I'm doing this kind of from memory, I think around November, Fifth Circuit Court of Appeals, judge stopped the implementation of the executive order. And so that froze it all up for everybody to kind of not do anything. And then about maybe, it was almost a month later, it seemed like it was right before Christmas, the Sixth Court of Appeals overturned that order, saying no, move forward, basically. There's a lot more to it than that, but I'm just kind of summarizing. So we're headed to this Friday, actually tomorrow. The Supreme Court is scheduled, and I'm summarizing some of these bullets. I'm not going to go through all these bullets. I am actually touching on them as we go through, so I can just get to this to the end. Tomorrow, the Supreme Court of the United States is scheduled to hear, I think, the Fifth Court's ruling. So the Fifth Court was the one that basically held it up. I'm not using the correct legal terms, but I'm using my language. They stopped it. So the question on the table for the Supreme Court Friday, at its basic level, and gentlemen, correct me if I'm wrong, is to answer that question, whether to stay with the Fifth Court's decision and stop it, or allow the Sixth Court's decision to render supreme and move forward. And they can paint with a broad brush, as Chuck has explained to me a million times. They can answer a variety of other questions if they choose to. They're the Supreme Court of the United States. But I think that first basic question is at least have to be answered tomorrow. No one knows what will happen tomorrow. No one knows if that question will be answered with one of the two, which side, and also will they choose to paint with a broad brush and answer questions that they weren't even asked, such as we're against it and here's why. Even more further, you haven't shown any evidence that OSHA, has the authority to be doing this, etc. So there could be a variety of things come out of tomorrow. That being said, the question on the floor is if it holds, it'll be from the Supreme Court, which is the end-all game here. It's going to go to a lower court at that point for basically more discussion. And at that point, there'll be a decision come out of that, and I anticipate it'll get ping-ponged back to the Supreme Court. So if they don't answer but the basic question, stay or hold, it's going to the lower courts, more decisions in terms of the nuances about OSHA and their authority, et cetera, and then probably and most likely appeals back to the Supreme Court. You say to yourself, probably, why don't they just go ahead and answer tomorrow? But that's kind of how the courts work. So that being said, staff is kind of okay. If it stays, we've got Josh Dobson's office will have to go through a process because we're a state plan agreement state where we are under the federal umbrella. And so basically Josh Dobson's office, if it were to stay and become a regulation, they're going to have to go through a process of approving at least that regulation. They can always be more stringent, but they can't be less than what the federal government would approve. And so Josh's office has not put anything, to my knowledge, even as of yesterday, any guidance or anything making any predictions about tomorrow's outcome. And I think there'll even be timelines. Should tomorrow be stay with the program and move for the deadlines, he'll probably have to go through a process where he adopts those things and then gives counties and local governments in North Carolina time to implement. There are timelines in the federal section of this. January 4th, which is past now, but I mean for folks to have received vaccination doses and then headed to, they are already made statements on NCDOL that they're not going to issue any citations before January 10th and that their testing requirement piece would not be a requirement until February 9th. So there are some timelines for them. Again, Josh may have different timelines the way I understand it after he was adopt these regulations. I have dug a little bit and found out that the Board of Commissioners is exempt from this. You are not considered part of the personnel wing of this 100 employees, and neither is the sheriff or the Register of Deeds. They are, again, back to that concept of their own personnel entity. With the Register of Deeds being under 100, they would have a pick and choose. The sheriff has more than 100, so he probably is not going to have, he would fall under the same rules and guidelines that are issued to these 100 employees. There are ADA accommodations and exemptions, medical exemptions. I read through them. They were very detailed, asking folks to prove that they are allergic to the chemical makeup, essentially, of the vaccines. and there is a religious exemption. That one didn't appear to me to be quite, it was up to the employer as to how, stringent they wanted to be with that. There are fines, $13,600 fines. It doesn't really go into a lot of detail. It calls it per incident. We don't know if that means per employee, per record that isn't valid or isn't kept up with, because there's stringent record-keeping requirements with this, should it stay and go forward. Willful non-compliance is what they call. They can take the fines up to $136,000 per incident. And so we've kind of talked with NCDOL and early, months ago, as long as you're kind of in a process of doing something to move forward with this, should it stay again, that willful non-compliance is probably not going to be something they're going to lean on everybody with about right now.
On the unvaccinated, they're required to take these tests, but are we having the same difficulty in this county that's throughout the country, that they don't have enough tests?
I'll get to that in just a second. I'm just setting the stage with the court right now. Let me do the on the ground here in a minute.
Sorry.
No, you're okay. You're okay. It's a lot to this, and it's so very, very complex. I'm just trying to get to the real good highlights so we can have a good discussion. So Friday, tomorrow, is a key point in this argument, if you will. And so staff is looking at it like, well, okay, if tomorrow becomes a situation where they uphold the Fifth Court's decision, we would continue with the path that we've on now. We're not looking to implement any aspects of this. But should they let it go to where the Sixth Court's decision is the way in other words, basically say, let implementation go, the country needs to be doing that, and they'll figure it out while you're arguing at the lower courts. Then that means these deadlines start to become a little bit more serious. NCDOL is going to have to start making some moves. So basically, what we could do, one option is, again, if the court tomorrow they just go with the Fifth Circuit, we do nothing. If they go with the Sixth, one thing we could do to stay in that non-willful, non-compliant area is simply count how many vaccinated versus unvaccinated folks we have. You got to know that number before you can even implement a strategy of, you got to know your volume, how many people are we dealing with, and then come back to the board with a plan later and monitor some of this lower level court activity, and maybe things change, because things have rapidly changed with this just in the last few weeks, after the Sixth Court and the Fifth Court did what they did. If you flip over to the second, that's the summary of this first page, which has a front and back. That's the court, the laws, the fines, everything that I know in bullet points of that part of it. If you flip
and this is not a question, but it is a question. Does this include the 77 industrial businesses we have with over 1,000 employees?
Yes.
Okay.
Right. And if you remember really early on, when I brought this to the board's attention, just, kind of keeping you updated, I kind of pulled you a little summary of how many employers have over 100 employees that I know of, so you could get a sense of how many employees we're talking. As best I recall, it could affect upwards of 15,000 employees in the county. But yes, those businesses will have to adhere to this as well. The second page is the on-the-ground part, Commissioner McClure. What does the testing look like? The requirements for HR to keep up with the records, et cetera. Tony and Casey's here, and these gentlemen can come up if you want to, if you got specific questions about that. But basically, at its core, what would have to happen is, if you're vaccinated, you've got to give HR proof of that, i.e. the card or some other verification. They keep that for in case someone comes calling from NCDOL. If you're unvaccinated, you go through a weekly testing regime where you supply records to HR proving that you've had a test. It doesn't have to be PCR, it can be antigen. And I can tell you I've had 2 antigen tests this year at CVS. You schedule them online, you show up, you go in a little booth outside, you rub the thing in your nose, you get the results back in 15 minutes. I'm not trying to belittle, I'm just saying that's a process. I showed them my insurance card, so it's charged to the county's insurance, essentially. Now, I've asked Larry Reese last night how that's going to work if this were to go forward, because Commissioner McClure, yes, if this goes forward, I anticipate, not just here, in this state and in this country, a massive testing shortage. A massive one, because there aren't enough tests, as you know from watching the nightly news, to do this now, much less if this becomes real. So that's gonna be an issue, and they know it, and I hope they take that into consideration, because that's gonna be a problem. But I'm letting you know, I have gotten 2 tests in 2021, that weren't PCR. In other words, it didn't take 2 days to process them, and those are accepted in this. I did read home tests. They apparently allow that with a proctor. In other words, you can't just turn it in on your own self-record and we take your word for it. So there's some details of this thing that has got a lot of issues, if you will. While you're unvaccinated, you have to wear a mask here.
Is that in the agreement that they have?
That's in the rules, right. That's, you wear a mask, and then while you're waiting for the test, I think you gotta wear a mask.
Yeah, even if you've received one vaccination shot, in between the first and the second, you still have to wear a mask. And then there's a timeline of 2 weeks after the second shot.
You know, that's gonna put a lot of extra work on the health department.
Well, oh yeah, there'll be some folks
And
coming
what
to
I'm
test,
saying by
yeah.
that, with 1,000 employees, and you said in the county we had maybe, it was 70-some, if I remember, different businesses that had over 1,000 employees. You know they're gonna be calling the health department saying, how do I do this? How do I set this up? How do I keep records? So they're gonna have to do a lot.
Right. And I don't wanna mislead you all, and these gentlemen as well can confess to this or tell you, we are still uncovering pieces of this to this day that we didn't see before, because some of the details now are coming out. So we're letting you know this morning, basically, is here's what we know. There's probably some things we don't know. Right. But what I'm asking for the board this morning is, what is the appetite for at least doing step 1? Should tomorrow not go well in terms of administratively around here? If they uphold the 6th court's decision, can the board allow staff to go ahead and at least get the count of unvaccinated versus vaccinated? We will have to come back to a subsequent meeting with an actual plan that's addressed on the ground and move to that place, so we're not in that willful non-compliance area. But if tomorrow goes where they uphold the 5th court decision, then we're right back to where we are today.
And even if you give us the okay to move forward, we won't be able to move forward to get that count starting until probably Monday or Tuesday.
Right.
So it's not like we'll leave here, shoot an email out, and create that. We will know tomorrow's decision before we move forward with trying.
Because it's going to be a huge undertaking just counting that for 1,000 employees. It's going to be a lot.
Tony, you got a specific employee. You request that data from that employee. What is your method of requesting that data from that employee?
We have to see the vaccine card in person, much like an I-9.
What if that employee tells you that's my private business, it's protected by the HIPAA laws, and I don't have to give you anything?
Yeah. The law does not tell us what we have to do. It does tell us that we have to have something in place in terms of how we're going to handle that. The only mechanism that I'm aware of at this point is some type of disciplinary action process. And what we have Casey and I have worked on it a little bit, what we've kind of outlined is a series of verbal written warnings. And then at some point in time, if they continue to not give us that information, we shoot ourselves in the foot.
That could be a dilemma.
Huh?
I'm not pointing the finger, I'm saying that could be a dilemma.
Oh, it's going to be.
My
Well,
understanding
look at what's happening.
Nobody's ever contested as far as the cards, but they don't have to tell you anything about pertaining to their medical issues.
But if they say they don't want to show you a card, then you count them as an unvaccinated person.
What he's saying is, after a while, you gotta fire him, that's what he's saying.
Right. It's eventually, if it got that bad, it would have to be a disciplinary process, you know.
Because we can't allow them,
or
the
pay
law
the fine.
won't allow us to let us keep them in the workforce.
And that's the conflict, because nowhere have I seen where one law overshadows the rights of another law.
The EEOC has said that we can see the vaccination cards. It's treated like a drug test. drug test, according to ADA and the EEOC, we can get that information. It's not like other medical information.
Well, that's
It is-
why I was asking it, 'cause I don't know, you know.
Yeah, so we can legitimately ask for that, and it would be okay. But it is a perception that it's medical information and it's none of your business, and that's the dilemma we have. And then you get into the whole termination thing, it's like shooting ourselves in the foot, and it's, I mean, you hear those reports now, hospitals who've terminated nursing staff, and it's a mess.
And we can't find employees now, so.
Mecklenburg County had 600 employees that just walked off and said, I'm not doing it. So, I mean, you know, if you look at that, we're 1,100 employees. If 600 of them walked out.
If you take the county's vaccination rate and apply it to our employees, we have about full-time and part-time, about 1,100. And we're talking between
We could be talking 400 to 500 employees that are potentially unvaccinated.
So here's my question. I understand the Sheriff's Department Register of Deeds. Do we take these like per department, like the tax department? They got 40 people. Are they exempt from this? Or is this a county as a whole with the exception of the Sheriff Register of Deeds?
Well, I thought we decided the sheriff's, no, sorry.
Well, the sheriff's in because he exceeds 100. He has to deal with it on his own, is what I'm saying.
Yeah.
In other words, he has to do, technically,
Implementation of his.
right, he is the
Okay, but it's a
implementer,
it's a county as a whole, not
right,
per department.
right.
Exactly. The only reason registered deed is not is he's under 100.
Yeah, he's only got 5 or 6 employees, so he's not gonna meet the 100 threshold.
What do they have to do to prove religious objection to be exempt?
We have, honestly, have not gotten that far.
It wasn't,
It's not-
it wasn't as bad as the medical.
I mean, you don't get a card from your church.
No, we would require some kind of a letter from some. We honestly just have not gotten that far yet. I'm sorry.
And also, I guess what I'm hearing you saying, if they don't want the vaccination or they don't show you their card, they would have to take the test every week.
Correct.
Right.
Every week they'd have to turn in a test to their supervisor, then it gets to us.
Yeah.
So every Monday, or it's really every 7 days. So if we have folks like in EMS or the Sheriff's Department who are varied schedules.
We did find out yesterday Thomasville's gonna run, is it via the state? A free testing center over in Thomasville. So maybe there's going to be other avenues to get testing too. You still got the fairgrounds, like I said, you got the pharmacies, et cetera. So, I didn't come prepared for much more conversation on the ground parts of implementing just yet, because again, we don't know everything just yet. Today's question is, should tomorrow, and that's really, I want to reiterate that, should tomorrow be an uphold of the sixth court's decision? Do we move forward with just simply getting that count and we'll be back? If they uphold the fifths, we just stay where we are.
Sounds like we have to.
Right. Then we can answer the questions about the religious exemption.
And we can also watch the developments that occur between now and early February. These court cases are going to court on a record speed. I'm actually kind of surprised at how fast they're getting them on. These usually take a long time, but these folks in the last 60 days have gotten through 2 Court of Appeals and are now getting in front of the Supreme Court. So
hopefully the Supreme Court will say how unconstitutional this crap is.
I agree.
And also, I see
Scenario.
where the employees is responsible for the testing cost.
Right. They're the cost. But however, as Casey mentioned, it'll be turned into the insurance.
But the insurance companies is gonna start denying those after a while because they don't want to.
At some point, and we've had that
that's a conversation we can pick up the tab as a county. The problem with that's going to be finding a vendor who's not going to charge a premium to do it, because now the supply and demand issue.
Well, let me ask you another question if you're through.
No, go ahead. I got one last thing and that's it.
Based on the supporting COVID-19 vaccinations highlight, the 2 days they're referring to, does that come off of sick pay, or is that additional time that the county has to come up with and fund?
Help me with that one, Tony. Where you at, Commissioner Shields?
We gotta pay them for 2 days and 4 hours,
Yeah, it's basically an additional benefit.
It is. It will be an additional benefit, correct. You have to allow for the time to them to
So
do
that's
it.
additional monies that we're gonna have to appropriate.
Well, it's
for.
time missing from work, yeah.
Yeah.
could be 4 days off work if they sick with
For
both
two,
shots.
yeah, for the 2 shots, 2 days for each one.
And then,
And then
4
the
hours
time.
each time
Yeah,
to another
forget
day there, so
Yeah.
basically a week.
There's another issue here that's gonna come up. I mean, I thought I had read early on what was considered fully vaccinated, but I think maybe I read it for Johnson & Johnson. So right now, fully vaccinated under the two companies, Moderna and Pfizer, is 2 shots. For J&J, it's 1. I don't be surprised if they add boosters to this. The
Yeah,
way these ETSs work is they are supposed to get public comment on them at the federal level, and they are only supposed to last 6 months, to my knowledge.
Fair.
And then they're supposed to be, quote unquote, go through a process of public deliberation to be essentially re-upped, if you will. And then usually when that happens, they become a permanent fixture in the OSHA code. And once that happens, NCDOL will have no choice but to amend their code to accept it. Because again, being under the federal umbrella, and it's about 50-50 in the United States as to who is under the federal umbrella in terms of OSHA and who's not. So there's half the country that won't have to adhere to this because it doesn't include public employers. But for us, we're unfortunate enough we're not in that position. So Josh and them's office will have no choice but to approve at minimum what the federal government gets by the Supreme Court. If that makes sense. They can always be more stringent, they can't be less.
Right.
So, and that would be state law issues there. So these things are getting complex quick, and then like I said, tomorrow is a key part of this. So,
But there's a law, a general statute or something that says that we can force an employee to tell us about their personal health stuff.
Just the vaccinations. what
Only,
these,
only that the EEOC has said that it's not a violation of ADA.
And you telling me that I have to tell you whether I'm vaccinated or not is one of those
Yeah,
exemptions.
And then according to this law, that the ETS, yeah.
the federal government also is giving you the authority to ask as well,
Yeah.
right?
Feel free to jump in.
Yeah, I'll jump in here.
Hey,
So, and this is where I guess the unique interplay between federal and state law, comes up. This ETS was enacted pursuant to Congress authorizing, OSHA under the Commerce Clause of the Constitution to pass laws that relate to the labor market as in the aggregate, which, the Supreme Court has held for 50, 60 years, does in fact impact interstate commerce. That's how Congress can act. If it doesn't and this is deep constitutional law, so I'm not a learned constitutional lawyer, but I'll answer your question as best I can. And so basically the question with this ETS, and this is where I expect the Supreme Court to really focus their attention tomorrow, is that does this action implicate interstate commerce, and therefore are they allowed to act in this way in a manner that's appropriate under the Constitution? If the Supreme Court says yes, Congress has validly given OSHA this authorization, and OSHA has shown its work, to borrow from an old law professor of mine, with regard to this action, it can do so. If the Supreme Court says, well, even if we could do this hypothetically, OSHA has not done a good enough job with this particular ETS in, quote, showing its work. In other words, how did we arrive at this decision? Then it will strike it down, or at least it'll re-implement the stay of enforcement until the lower courts can work through the legalities of the issue at a much lower level. The state law in North Carolina is that, pursuant to the state plan, as Casey set forth perfectly, is that North Carolina will adopt what OSHA does, what USDOL does, at a floor level. It can do more, but it can't do less. And so if the Supreme Court tomorrow upholds the stay, or excuse me, if the Supreme Court upholds the dissolution of the Fifth Circuit stay, and then allows implementation to take place and allows the federal government to begin enforcing this mandate to either test or to vaccinate, then DOL will have to, by law, based on the agreements and the way that the supremacy clause of the Constitution works, they will have to adopt a law or regulations that match this in general terms. Now, can the federal government come in and enforce us to do it the way they could some other state? No. Our enforcement will come through NCDOL, and that will probably take, I'm going to say 30, 60 days minimum, probably closer to 90. But to answer your question, yes, if the dissolution of the stay allowing implementation is upheld by the Supreme Court tomorrow, and I would expect a decision probably mid next week. It's going to take a couple of days for them to work through this. But let's say that they do uphold the Sixth Circuit's decision, then ENCDOL will have to, by law, to begin acting on this. And then we will have a decision to make, do we follow that or do we not? And if we don't, unfortunately, there's some potentially some negative consequences. I think, I don't want to get too far into the religious thing, but the ETS does allow the employer to kind of dictate how it arrives at that decision. So you mentioned, a card or something like that. How we arrive at that decision internally, I think, is going to be largely left to us. And I would assume NCDOL will give us grand and broad discretion to decide that. But
it's much broader than the medical.
Sure, yeah,
Right.
yeah. It's much more open to interpretation and low level implementation in terms of on the ground with the employer. But yeah, unfortunately, if tomorrow, if the Sixth Circuit's dissolution of the Fifth Circuit's stay is upheld, then yes, the NCDOL will be forced to begin the process of implementation, and we would almost certainly have to do so as well.
So yes, yeah, right.
Yeah, sorry.
No, it's okay.
You mentioned something about Congress approving, but this is an executive order from the President. Congress didn't have nothing to do with this.
Well, so yes and no. So in September, President Biden basically issued an executive order directing the U.S. Department of Labor and OSHA, which falls under that, to begin this notice and comment process, this rulemaking process. That took, I guess, 45, 60 days to do. On November 5th, they being OSHA, published this ETS. And so it is under the regulatory authority of OSHA as an agency, falling under USDOL as an agency, which is authorized. Congress has authorized these ETSs. Congress has given OSHA, with its enabling statute, the authority to issue these ETSs. They've issued, I think, 12 roughly in the last 40 or 50 years. Essentially, the Fifth and Sixth Circuits really look at three primary questions. Number one, does the statute allow an ETS generally? Number two, is COVID, the ETS requires, quote, a grave danger. And is COVID a grave danger? And then the third question, which I think is where the Supreme Court will focus its attention tomorrow. Assuming the first two are yes, did OSHA explain how this mandate will alleviate the grave danger? The Fifth Circuit, I think, honestly pretty convincingly talked about how this is both, it's too broad and it's not targeted enough, and that it encompasses only roughly 66, 70% of the workforce instead of 100% of the workforce. And also, as we all know, unfortunately, COVID is not just a workforce problem. It's at the grocery store, and it's on the bus, and it's when we go to Walmart. And so, it's not just something that we can address in the workplace. It's a one-size-fits-all approach. So I think that's, quote, the low-hanging fruit for the Supreme Court tomorrow. I think the narrow question will be, do we allow this to go in place or not? I think practically speaking, tomorrow may well end the issue one way or another, just because it's going to take several months for the lower courts to work through this one way or another. Hopefully this all is behind us here in a few months. So, I think, it's very hard to predict.
There's two other litmus tests they had to meet, if I understood. Financial burden on society was one.
Sure.
So that'll come up, which is an obvious, I'll leave that one to your imagination. And then the other one is, there is an argument to be made if you're a good lawyer. Well, I say you're a good lawyer. This is low-hanging fruit, too. It just says 100 employees. When you put 100 employees in a building the size of a football field, it's different than 5 employees sitting in a 800 square foot. See what I'm saying? They didn't do a really good job of defining that. So if you're a good lawyer, you attack those things. I'm just saying all that to say there's a couple other litmus tests. The burden economically to society is one of them.
But don't you think
As
they'll
far as the
take into
testing and the
consideration,
problems with all that.
don't you think they'll take into consideration that the infection rate that was at 5% is now at 29%?
I won't pretend to take, and I won't even pretend to guess what they'll take into consideration. I have no idea. I don't even want to speculate.
I think that might speak to the grave danger part of this that the Fifth Circuit vigorously attacked, and the Sixth Circuit, I'm not going to say waived, but basically said, yeah, we're satisfied it's a grave danger. But I don't think it answers the question, and to what Casey just said a second ago, is does this ETS and its mechanisms actually address the problem it's supposed to address? And I think the Fifth Circuit put that pretty well, the Sixth Circuit dissent. There was a dissenting judge who disagreed with the Sixth Circuit's opinion. He also kind of targeted and honed in on that are we actually doing what we say we're doing? And I think, if you're looking at, if the court wants to avoid controversy, and Chief Justice Roberts is deeply interested in avoiding controversy with the court, I think they'll target in on that, and that's where they'll.
The fatality rate is what? It was like, the 97 point some odd % of the people, recover or not fatality.
Sure.
I mean, you're only addressing 3%. How could that be a grave?
That'll be the argument for the,
That will be an argument, and it has been made, absolutely.
And how much of that happens in the workplace? And how much can you push that toward the workplace? And I see what you said.
What Andrew's
Casey.
trying to say, real quick, I'm summarizing something here, I'm not trying to is there's two basic arguments. Does OSHA have the right to do this? Well, Congress has answered that, yes. But did they do this correctly in their design of the plan to attack the problem? That's really the one that's gonna be in question, and that's up for debate.
And again, employer of 99 don't have to do it.
Right.
One more.
Right. And that'll be some, economic impacts from that. Right.
Congress have to do the same thing?
Sorry, what?
Would Congress have to follow the same procedure?
Congress could always revoke or expand this right. I mean, they certainly could, or not right, this ability of the agency to pass this type of ETS.
Yeah, I'm talking about as a unit.
Do they have to
Congress
get the vaccine? I'm not. I thought I understood they were treated much like we found out.
I'm pretty sure they exempted themselves and they don't have to do this, so.
The requirements of this just require don't require you to present a card. You could do it by verbal assent. I mean, if it doesn't specify that you have to present a card, then you could ask the employee, have you been vaccinated?
I thought I read somewhere where there was a provision if
you're shaking your head, but show me in here where it says you have to have a card.
We don't have the full law in front of us,
Yes.
so yeah.
The only other way you can do it is they've already got the forms filled out, where it'd be like a proctor. So let's say we lose our card, or our card is damaged to where we can't see it, so you're gonna have to sign off on saying, at one time I did have the card, and we'll put that in the file with it. So technically, you don't have to show it to us, but you gotta sign something off saying that you did have a card sometime.
When you're vaccinated, don't the CDC get copies of that? I mean, aren't they notified?
Yeah, I think all that stuff's fed today.
So, I mean, if they've already got it, why are we, can we not get that from the feds?
State's got it in their computers right now.
Tell you the truth, I think all of this is irrelevant until we have a law from the North Carolina Department.
I would agree with that.
Of what
I would
we
agree with
need
that.
to do. So, and like I say, again, tomorrow, the Supreme Court may give a decision and all this is over. So we sitting here talking about all these hypotheticals.
Well, and that's why the question on the floor was just wait till tomorrow comes and goes. If it doesn't, if they uphold the stay, if they don't, then step one is the obvious, just figure out what you're doing.
I mean, they can't get us to breaking the law until we have a law to go by.
Correct.
Also, we're talking about testing now. Yesterday, our health department was busy all day with testing. There's people in line over there testing all day yesterday. So we could probably get to, go through them with our testing if we had to, if it becomes necessary.
So like Todd says, we don't know which way to jump, so we just wait till the decision of the Supreme Court comes down, then we'll try to see what we get. I would imagine that if the Supreme Court makes a decision to let it go, that we would receive a more definitive order so far as what the statute would say.
The state.
It wouldn't be so general in nature.
Well, then, like I said, the Department of Labor's gotta write the law.
And they'd have
at
to
least
hire,
equivalent to the.
they'd have to hire another 1 million people just to enforce it for every company over 100.
It has provided some guidance, and they do have a plan that we are working from, a template that they will use that mirrors the federal. So they already know it's just that they haven't adopted it yet.
And so would the Department of Labor do the inspections or? Yeah, okay.
And it's based on complaint.
Is there, how big is this template?
10 pages? About 10 pages, 9 or 10.
7 pages?
10.
10.
9 to 10.
How about getting that to each one of the commissioners? I'd like to know what it says. But wait until that decision's made. If they say that to go ahead and enforce it, then I'd like to see it.
Yeah, don't waste the paper till after tomorrow.
That's right. Well, it's actually
Well, probably
gonna be
midweek next
probably
week before we get a
2 or 3 days after
decision,
that.
right,
They'll make a
Chuck?
decision tomorrow, but you won't hear about it.
So I wanna make sure I'm clear. Are we, cause I'm hearing different things. I just wanna make sure I got it. If tomorrow doesn't go where it's stopped, are we moving forward with at least counting of the vaccinated and unvaccinated, so we have that information ready as we move on for Josh and them when they start to implement the plan or adopt their plan?
I don't think we ought to do something like Commissioner Yates said until we have a law in front of us that says do this. Cause otherwise, I mean.
We're gonna have one if tomorrow doesn't happen. That's why I'm asking.
But it ain't gonna be tomorrow, it'll be midweek.
Well, no, I know it
next
won't
week.
be immediately like that, but
No, but I'm just saying, we won't even have a decision, I don't think, tomorrow. Do y'all think we'll have one tomorrow?
No, I don't mean do it as of tomorrow immediately, 5 o'clock or Monday. I mean after tomorrow comes and goes and we have a decision. If the decision is to hold this thing in place from the Supreme Court of the United States, that's gonna set a precedent for the lower court to work from, it looks like to me, where now they've weighed in on it. That means a law is coming from Josh's office inevitably, a few weeks later. We're gonna have to do that count at that point in time. So I'm asking, are we gonna do it now? I don't mean now meaning Friday. I mean after the decision. Or are we gonna keep waiting? Cause step one is we gotta know what we're dealing with. 500 people or 10 people or whatever.
Let me ask you this, this thing could go back to the lower courts to fight for a while, correct?
Almost certainly either way.
It would, and there would be an appeal process there to move it
So,
back up.
Again, I think we just wait until we see.
I agree with that.
Can I ask, if they send it back, the Supreme Court could either still put a stay on it or injunction or whatever the legal term is, or stay, it's still moving forward until, so we could get one or the other if it gets kicked back. Is that right?
Yeah, so procedurally, the question tomorrow is that, I'm trying to answer both, is that either A, is everything on hold, so no one can enforce it. We can't enforce it, state, federal, no one can enforce it until, the lower courts, the trial court, however, work through this and, reach a verdict or settle or whatever the case may be. Or, while all that's going on, do we allow implementation to occur? And I think the practical application is tomorrow is deciding, is this actually going to mean something or not? And the time to work through a court case will be weeks or months. It may not matter then, either way. So, I think practically tomorrow is about, will we actually have to do this or not?
There's a chance that they would rule whether or not the executive order was constitutional or not. They would, that way it wouldn't refer back to anybody.
I think, I don't know if that's a specific question for the court. They certainly could address that if they so choose. Again, as noted earlier, they have wide prerogative to address whatever they want to. I think it's unlikely just because the issue tomorrow is, again, to borrow a term, it's low-hanging fruit.
Right, tomorrow's question is very simple. Let it go, be implemented, or stop it. It's very simple. Now, it'll continue being argued at lower, but again, what they're doing, you're talking about the Supreme Court of the United States setting this, they are the end of the line. So if they say let it be implemented and it goes back to a lower court, yes, there'll be appeals and move forward, et cetera, but at some point in time, it's starting to, the process is beginning at that point.
All right, let's wait to see what happens. We can kick this can around for a while. Todd said that, and I agree with him as well. James, yeah, we don't need to be implementing anything, I don't think, until we find out what we're gonna do. I wouldn't wanna go ahead and ask people to present a shot card and then the decision go the other way. I just don't wanna do that. Does everybody agree with that?
Everybody?
I agree with that, yeah.
Yeah, I agree.
Okay.
When we have an actual law, then we can do something.
We're not gonna be the only county and municipality that is waiting to hear.
And I
what the
did
court's
find
doing.
out from Larry just a minute ago, the testing's probably not gonna be covered under, Blue Cross Blue Shield.
We
indefinitely.
figured at some point they would accept it for a couple of times and then.
So that means payment of the testing is gonna be a burden on the employee unless we pick up the tab as the county.
A lot of the, insurance companies are required by law to provide preventive care at no cost.
That's what he said. He said preventative care is fine, but just testing in general to meet the ETS might be an issue.
It's just another way then to force people to try and get
I
vaccinated.
don't know, I think that it would be under preventive care if you're tested for it.
Well, I was using me as a reference point. Like I said, I've gotten 2, and mine weren't for close calls or anything like that, so I don't know. But maybe because of this, the word's getting around the country and all the Blue Cross Blue Shields in different states are saying, look, you know, we're not gonna be a part of having to cover millions and millions of dollars worth of tests, you know, because the federal government's mandating this, so I don't know, but that was his text to me.
All righty.
All right, we'll keep you posted, we'll watch for tomorrow, either be back or not, so, thank you. Thank you, Tony.
Mr. Smith, D, under 7?
Yes, sir, we got one more here.
Did you throw all these things on at one time?
Do what?
I think you threw all these things on at one time.
Well, these were
Oh, Wayne,
building up.
time for me to go to work again?
This last one here. I think this one's, becoming clear, hopefully. Andrew, we might need you for this one more time.
There's some more.
This is Senate Bill 473.
Yeah, Mr. Chairman, members of the board, I want to give you just a quick update on this, Senate Bill 473 that got passed, I guess, early fall. And I just really want to call your attention, if you flip the bill itself, this is a copy of the bill, but flip it over to page 3. Andrew, come on up, because, there's some back and forth, even between us and NCACC about this one. There's a lot, this was some kind of, transparency bill that this General Assembly passed. I talked to Senator Jarvis about it. I think my intuition was correct. It had a lot more to do about a particular entity in North Carolina. Some local government got maybe run a little afoul of some nonprofits, and so here this bill gets passed. First time I saw it on page 3, the highlighted in yellow section was the part that caught my attention. The entire bill doesn't really affect us as much, and as you know, I'm setting the stage for here. We don't fund nonprofits, so this is not going to be as burdensome on us as it is in some other counties. But the yellow part did catch my attention, where basically from Part A down says that you know, any of our board members that are on executive boards for nonprofits, if we're providing funding for those nonprofits or entering into a contract with them, they would need to abstain or recuse from a vote for that. And so that administratively creates a little bit of an issue, and that's what caught my attention. So that's why we've asked you, and I think Jason's wanted to ask, you know, give us a poll of we know what committees you're on that are part of nonprofits, but we didn't know if you're on any others, like a fire department or anything like that. And I think we got to the bottom of that, and it wasn't very many. I know what most of you are on, so I kind of knew instinctively whether we had an issue or not. This won't bother us even if it does at all now, and I'm getting to that in just a second. Come spring, come budget time. We don't do off-budget appropriations to anybody or contracts, so I'm not worried about this until about June. I'm just bringing it to your attention as an update. If at that point in time we have any nonprofits, I'm thinking possibly, and I'm going to get to the possible in a minute, EDC, TRIP, I thought maybe even initially Sandhills, and even some of our memberships with NCACC, which I know you're still executive member of that, or the COG. I was wondering, does any of these qualify under this bill before, you know, because we all appropriate money to those agencies, whether it be a membership or just part of it. Nobody's on rescue squads anymore that I know of, again, fire departments, et cetera. So those were the ones I was kind of targeting in my head. And again, what would happen if they were part of this law would administratively, come June, we would just pull them out of the budget ordinance and we'd have to vote on them separately, and the members of those executive boards just have to recuse themselves. However, yes.
Couldn't the people, if we just have 2 or 3, couldn't they just recuse himself from that discussion rather than having to go through a whole bunch of stuff?
No, the law here says, and Andrew helped me out, I'm going to get to Part D in just a second because epiphany on this last night, but it basically says a governing board member of this board that sits on, or a member of this board that sits on a governing board, an executive board of this nonprofit. If you're giving money, if this board's appropriating money to that board, yeah, you gotta recuse yourself. And it goes through that process. It says you've gotta do it with the county clerk of court, and recuse yourself. So that was, administratively, I was sitting there thinking, okay, it's not that big a deal if we just pull them out of the budget. But then I saw last night Part D where it talks about excluding any political, any political subdivision of the state or that entity created on their own. And so we created EDC, you know, the counties, all 100 created NCACC. Sandhills is a state creation. The airport board is a state creation. The COG is a state creation. So I'm not sure now if we've even got any on the table. We possibly don't. I do know NCACC is a little worried about this for their members and doing exactly what I just said, voting on being a member of the budget, because all 100 counties are members of NCACC and pay membership dues. So Amy Bason's following up. Yes, sir.
I hate to interrupt you, but to Fred's question, I think you just answered that, and I think that's what it's. Anybody could continue to sit on that board. They would just have to recuse themselves when it comes to voting rights.
And it doesn't read to me, Andrew, correct me if I'm wrong, not at that board, executive board meeting, but here, appropriate money. Yes, you can still be on the board. Yeah. Right. So if it was to hold true for NCACC, for us to provide membership dollars to them, we appropriate those dollars in the budget, right? So if you stayed on the executive member of that board, come June, if this law were to apply to that, I would simply pull that out of the budget ordinance and we'd vote on it separately with you recusing it because you're an executive member.
That's simple enough.
That's the way I read it. But again, Part D downstairs says exempt is political subdivisions of the state, and if those political subdivisions are creating one. Again, all 100 counties made NCACC, so I can make an argument that is a creation of the counties. So I'm going to get Amy with them and run that rabbit. I don't know how you've had time to look at it, but between Amy and you and your office, because she's concerned about it too, and I think what they're going to do is they're going to approach the General Assembly and say, can you reword this little section a little bit clearer so everybody understands who's in, who's out? Because you inadvertently created the law of unintended consequences. You created administrative burden for counties and cities they didn't need.
Okey-doke.
Because if you try to recruit yourself from one, a thing like COG, like Meals on Wheels, it goes to every 13 counties. So.
Well, I know, but I don't know, is anybody up here, nobody up here is an executive board member of Meals on Wheels. So it wouldn't apply.
Meals on Wheels is a service of the
That's
senior.
That's the service of the COG.
And we serve on the senior board.
Would that be the same scenario as DSS contracting with private providers? Or senior services contracted with different?
Senior services gets all their money from
Meals
on Wheels.
The way, correct me if I'm wrong, Andrew, the way this reads to me is, use the Meals on Wheels as an example. Commissioner Troll used you as an example. He would have to, instead of being on a member of the Senior Services Board, who via the county is appropriating money to Meals on Wheels, that board member would have to be a member of the Executive Board of Meals on Wheels.
Yes, I think as we read it today, and there is some definitely confusion about this, but as we read it, they'd have to be an executive board member or of the governing board, whatever that word is, that term is, of that particular entity.
There is no board for Meals on Wheels. It's handled by Senior Services.
Well, so that's why I don't think it would apply here. I don't think this would apply.
Sounds like we're good to go.
I think we're close. It's just
Yeah, let's just wait till June.
A little bit worried more about some of these, like TRIP, for example, but we created TRIP, the county did. As far as I understand, it was before my time, but I think the county was involved in organizing that. So the way I read Part D there, it says, if we create, the political subdivision's us.
I'm sure you'll find out by June, so you can let us.
Well, that's really the update part of it here. If June we got an issue and we have to pull them out separately, we will. That's to adhere to the law is what we'll do.
All right.
Number next, I'm okay with dissolving that committee.
The I-85 Corporate Center call, are you through?
Yes, sir.
Okay.
Yes, sir.
Make a motion, we go into closed session.
Well, we got around.
Let me give you a little quick behind us on 9E real quick before we go to dissolving it.
70, right?
Yeah, 70.
It's 9, sorry, maybe it is 7. The I-85 Corporate Center Committee, the goal here is, I won't say we've ended our useful life, but we have a large committee for that started with a lot of members from around the county. And it was okay at first because all the members had to get together to figure out how to put the infrastructure in, all those kinds of things. We're at the point now, all infrastructure's in, and we're down to essentially 2 lots to sell. Any issues that come up from here on out, it's really very simple, sell the 2 lots, basically. So I think those committee members that are on there, first of all, let me give the 3 of you that are on there, and Karen's not here, just a round of a pat on the back, because people don't realize how much work this industrial park has been. I know they don't, because it just kind of popped up out of the ground and came to be. But the way it was built and us doing it on our own has taken a lot of thought and a lot of preparation. And it's a valued asset in the county. But we're at the point now where we're just on the margins. We're selling 2 lots. That's an EDC thing, and I know those members that spent so much time on that committee would be probably relieved to have a little break from it. For right now, it's very time consuming. We've got other issues on other committees to put our attention on. This one's not where it's at, so I'm proposing we just dissolve it for now. If we need to get back together or updates for those board members that are on that committee, whether it be with Ben Palmer or Craig Goodson, they can get with me and I can get it to the full board or those members, et cetera.
Would your recommendation be to dissolve it or
Make it inactive.
Yeah, we just make it inactive. You can re-do it later if you need to be.
If we need it, we can reinstate it.
That's what I was thinking about, if we suspended it, wouldn't have given us.
Well, let's move on.
I really want to give those 3 members a break, because it's to the point now where meeting is kind of getting cumbersome, locked up with the jail committee, sewer committee, and facilities committee. It's just one more committee. I'm not saying we don't need it, it's just we're at the point where everybody understands the game plan, we're down to selling 2 lots.
And I wanna thank all the members that served with us on that committee, all the other 10 or 12 or whatever it was. Like I said, it's a lot of hard work by those guys too, and I appreciate the time they put in. So, if anybody's listening, thank you, for your service on that I-85
Facilities committee is probably the most important committee we got right now. And
So
they'll
is
do a good
it
job.
to dissolve or to make inactive?
Inactive would be, 'cause we may need them again, and
If
it's
y'all,
a good,
because there is additional land out there to be purchased if y'all would decide to go that route at some point in time.
and it's a good group of talented people, so I'd say we just make it inactive, and, if we need them in the future, they're already there, so.
Motion go in closed session.
Second.
Aye.
Aye.
Okay.
Mr. Rick.
Okay.
Okay, Mr. Chair, we are rolling in live.
Motion to go back in open session?
Motion made.
Chuck?
Do we have a second?
Second.
Oh, I thought we done. Okay. Chuck?
Mr. Chairman, in closed session, the board considered one matter of personnel. The board gave directions to the county manager for negotiation of contract. That's all. Thank you, sir.
Thank you. If there's nothing else, anybody, motion adjourned?
Motion moved. Second.
Okay, all in favor?
Aye.